The United States has just witnessed a stunning and unsettling development that shakes the very core of its constitutional protections. In a move that few expected and many now fear, the Supreme Court has effectively weakened the Fourth Amendment, the vital safeguard that protects citizens from unlawful searches and seizures. This shocking decision has ignited a wave of concern across the country because it challenges long-standing rules that prevent racial profiling and protect personal privacy. For generations, Americans have trusted the Fourth Amendment as a shield against excessive government power. But today, that shield feels alarmingly fragile and uncertain. The case at the center of this controversy came to the Supreme Court through an emergency appeal, catching many off guard. Instead of a full hearing with careful deliberation, the court acted quickly, without detailed explanation, and allowed law enforcement officers to consider race, language, and even where someone works or spends time as reasons to stop and question them. Supporters of civil liberties see this as an open invitation to racial profiling and harassment. Think about it. Could simply speaking another language or looking a certain way become grounds for being detained? This is no longer a distant fear. It's the reality unfolding right now on city streets, in workplaces, and in quiet neighborhoods. As citizens debate the implications, the decision stands as a stark reminder of how swiftly hard-won rights can be eroded when the highest court moves in near secrecy. Before we continue, don't forget to like, comment, and subscribe to the African Web for more detailed analyses of major global events. Because understanding these shifts is key to protecting your own rights. The Supreme Court's ruling emerged through what is known as the shadow docket, a process often used for urgent matters, but widely criticized for its lack of transparency and public scrutiny. Instead of lengthy arguments, a full record, and detailed opinions, the court issued a short order with almost no explanation, leaving lower courts and citizens guessing about the boundaries of the law. The case originated in California, where a lower court judge had ruled that police and federal agents could not rely on race, ethnicity, or language when deciding to stop someone. That protection has now been stripped away almost overnight. Justice Brett Kavanaugh's concurrence, essentially his written agreement, stood out sharply. He argued that factors such as appearance, accent, and location could all count as reasonable suspicion, giving officers broader freedom to question or detain people. This sudden change means that an officer might now justify stopping someone simply because they speak Spanish at a job site, or happen to be in a neighborhood associated with immigrant workers. There was no full record reviewed, no oral arguments, and no clear guidance for lower courts on how to interpret the decision. Instead, a half-paragraph order reshapes decades of Fourth Amendment law and leaves critical questions unanswered. What does this mean for ordinary people walking to work, shopping, or visiting friends? Could any one of us now be stopped just for looking different, even when we are doing absolutely nothing wrong? This decision marks one of the most significant blows to civil liberties in recent memory, with ripple effects that may last for decades. For generations, the Fourth Amendment has required that police have individualized probable cause before detaining or searching someone, a principle repeatedly affirmed by courts across the nation. Judges have long held that broad generalizations, like race or language, cannot form the basis for suspicion. By removing these safeguards, the Supreme Court has essentially allowed law enforcement to treat entire communities as suspects, turning the principle of innocent until proven guilty on its head. Imagine being a U.S. citizen who speaks with an accent or works in a neighborhood where immigrants live and work. Under the new standard, officers can stop you simply because you fit a broad profile. This undermines the principle that the government must prove specific wrongdoing before interfering with personal freedom. It also increases the risk of wrongful detentions, as people may be questioned or even arrested despite having valid identification or proof of citizenship. History has shown that such policies disproportionately affect minorities and immigrants, leading to fear and distrust between communities and law enforcement, a rift that can take generations to heal. Civil rights lawyers warn that this ruling could inspire a wave of lawsuits and deepen divisions within American society. How can citizens feel secure when constitutional protections can be narrowed with a single unexplained order that sets such a far-reaching precedent? The decision has drawn intense criticism from legal scholars, civil rights groups, and even some members of the court itself. Justice Sonia Sotomayor issued a fiery and deeply detailed dissent, warning that the ruling eviscerates the Fourth Amendment and allows officers to rely on race and ethnicity as key factors in stopping individuals. She highlighted real-world consequences, people being tackled, zip-tied, and questioned simply because of how they look or the language they speak. Sotomayor argued that the court ignored both the facts presented in the lower court and the fundamental protections enshrined in the Constitution, protections that were designed precisely to prevent government overreach. Outside the court, advocacy groups have called the ruling a dangerous step backward, and protests have erupted in major cities as people voice their outrage. They fear it will embolden aggressive enforcement tactics and erode trust in the justice system. Critics also point to the hypocrisy of a court that recently ruled against considering race in college admissions, while effectively permitting racial profiling in law enforcement. Public reaction has been swift and passionate, with legal experts warning of a chilling effect on immigrant communities and anyone perceived as different. Many Americans are now questioning whether the Supreme Court is fulfilling its role as a guardian of civil rights or quietly undermining it. Can a society remain free if its highest court allows discrimination under the guise of law enforcement? And what message does this send to future generations? The Supreme Court's surprise ruling on the Fourth Amendment represents far more than just a legal shift. It is a turning point in the nation's understanding of freedom and equality. By allowing race, language, and location to justify suspicion, the court has weakened a cornerstone of American democracy and opened the door to policies that many believed were long buried in the past. The decision raises urgent questions about the future of civil liberties and the delicate balance between security and individual rights. Citizens now face the unsettling reality that their appearance or speech might invite unwarranted stops and searches in places they once considered safe. What does this mean for the promise of equal protection under the law? Will communities targeted by this ruling find ways to defend their rights? Or will this become a lasting precedent that shapes how law enforcement operates for years to come? Share your views in the comments, and let's discuss how this decision could reshape everyday life for millions. To stay informed on pivotal issues affecting justice and freedom around the world, make sure to like this video, subscribe to the African Web, and turn on notifications. Your voice matters. Join the conversation, raise awareness, and help shed light on the ongoing fight for civil liberties.